All right, so we're back here with Volume 2 of the Chris Gabehart files. To catch you up if you're new at this, Joe Gibbs Racing has sued its former competition director, Chris Gabehart, and that is now in federal court. And they additionally filed a temporary restraining order preventing him from working at Spire Motorsports. And additionally, they also decided to loop in Spire Motorsports themselves as part of this lawsuit now. So now we're going to read through and this latest filing, because now Chris Gabehart has responded to the accusations that Joe Gibbs Racing has levied against him in federal court. So again, to catch you up, they said that he took proprietary information from them with the intent to distribute it to Spire Motorsports, a competitor of theirs. This was done through linking his personal Google Drive, they say, with a folder called Spire on it. And in addition, taking pictures with his personal cell phone when he held his cell phone up to the screen and took screenshots of information that they had listed. That's all in a prior video. So this is just his response here. So again, this is Gabehart's response to Joe Gibbs Racing. He says that JGR's motion should be denied because there's been no misappropriation of trade secrets or confidential information, and no irreparable harm will occur. Basically, you don't need to have this temporary restraining order because the evidence is already shown with the device that I've turned over that I have not transmitted, distributed, used, or otherwise shared any JGR confidential information. Additionally, he says the facts demonstrate that JGR actually breached the terms of the employment agreement that I had with them by withholding payments to me and therefore voiding all the rights to enforce any of the non-competes clauses, which they are now trying to enforce with this temporary restraining order. So we go down, we start to find out his reasoning, right? First of all, he says that in their motion for the temporary restraining order, they left out some critical language that is actually in the employment agreement. He says, critically, there's Section 6 of his employment agreement, and the non-compete clause happens to be reduced to 1 week, and JGR must pay $100,000 if these dates, which this falls into, because remember, this happened in November 2025. So if it's a mutual release after September and before June that says the non-compete gets reduced to 1 week and JGR must pay $100,000. Okay. If he notified JGR of specific job duties or responsibilities assigned to him, okay, that were not consistent with his reasonable expectations for the job description that were provided before the employment began. So that's a big thing here, because he's going to go into and say why his expectations were not met. Also, he lays out the time here of when they had to resolve this and all that stuff. So he's going to say that was all part of this. So now we get into the nitty-gritty. During the 2025 season, he says, as the competition director, he became dissatisfied with certain responsibilities as part of this role and other aspects of how JGR's race teams were being run. And pursuant to that Section 6, which he mentions earlier up here, he says that he provided JGR with notice of this, okay? In fact, written notice that his job was not being fulfilled the way he thought it was with his reasonable expectations. He says, I notified JGR that the job was not at all as advertised. I was promised a COO, Chief Operating Officer type role, overseeing all competitive operations with autonomy to lead. So you're saying, hey, you said you were going to give me this role and let me lead how I wanted to. Instead, I found myself constantly intertwined with Coach Gibbs, senior JGR executives, and family members when making even routine competition decisions, which he calls a dysfunctional organizational structure that I could not continue in. So he's saying, instead of you telling me that, hey, I can just lead how I want to lead, all the decisions that I want had to go through Coach Gibbs, potentially family members here, so probably Heather Gibbs. She could fall under both of these. And so he calls this a dysfunctional organizational structure, and he doesn't want to do that. He also says that he raised serious concerns about the management of JGR's number 54 car, which is Ty Gibbs. That is Joe Gibbs' grandson. He says it was my view that Ty Gibbs' car should be managed and held accountable in the same manager as the organization's other cars. Instead, Ty Gibbs' team, the number 54 car, he never says Ty Gibbs in here, the number 54 car was managed directly by Coach Gibbs, and everyone in the organization knew it. Okay? Beginning early last year, Coach Gibbs repeatedly pressured me to take over as the crew chief for Ty Gibbs. I consistently declined, explaining that as competition director, I did not believe this was the right move, and it would undermine the long-term development of the team. So he's saying, I don't want to take over this car because I'm not going to be the crew chief long-term here, and so you need to start building this team with a bigger picture in mind. So he doesn't think it's the right move, and he doesn't want to be a crew chief, not only for Ty Gibbs or any other car. He's trying to be the competition director. Okay? So he's saying, despite my objections, Coach Gibbs and ownership continued pressing, and I eventually conceded to the pressure by first helping the Ty Gibbs team more behind the scenes, and then beginning in last June, by publicly serving as the crew chief and calling the races on Sundays for 9 consecutive races before he then turned it back over to Tyler Allen, the original crew chief. And he says when he turned it back over to the original crew chief, these were, quote, against the strong desires of ownership when I made it clear I did not want to serve as the crew chief for the long term. Okay, now it gets worse. There's more tea being spilled here. He says that he also identified specific examples of the number 54 team's differential treatment. So they're being treated differently than the other teams he's working with that undermine his position as a competition director. For example, he says, key personnel decisions about the 54 team were made without my counsel or input, despite my role as competition director. So he's saying I'm the one that should be consulted here, or maybe making the decisions, and these were made without me. And critically, Ty Gibbs was not held to the same meeting attendance standard as the others on the team. So he's saying Ty Gibbs either was late or absent at meetings. It says meeting attendance standards. That's not specified, but saying he was allowed to get away with stuff that others were not allowed to get away with, essentially is what it says here, allegedly. So November 6th, we remember on our last video, we talked about that was right after the season. He says, after that written notice and after many oral notices, so he's talked about this many times, JGR leadership, they're saying. He says, I met with Coach Gibbs to discuss these concerns in person. During that meeting, I reiterated the issues identified in the notice that he sent to them and expressed my desire for resolution. Following that meeting, Coach Gibbs and I agreed that we need to begin the process of working out the terms of separation. So they hash this out, or try to. They realize they're on different pages, and they were going to go their separate ways as a result of this is not what he thought it was. Now, in JGR's lawsuit, of course, they characterize this differently and say that he demanded a higher authority leadership position, and once that was not given, that he decided to quit. So after the meeting, it's determined that they're going to pursue an amicable separation. Remember, JGR says they offered a generous mutual parting of ways, and they both thought they were working toward a separation agreement Now, he says, I admit that the next day I took photographs of my phone, on my phone, of a JGR Excel spreadsheet file with multiple tabs and other notes that I created or had a significant role in their development. He says they were all relevant to his job at JGR. So he admits that he did this, and he admits that he has this. He went to his phone screen like this and took pictures, or use his phone to his computer screen. But he also says he understood his confidentiality obligations, had no intent to violate those obligations. He says, I did not plan to use any such information in future employment and have not done so. So now, a few days later, November 10th, JGR places him on garden leave, which is like, hey, you can't go work for another team. While we work through the separation agreement, they told him that if anyone was to ask internally where he was, he should just say he's on vacation. November 8th, we go back a couple of days, JGR's chief financial officer, there's text messages he included, which I don't have. I'm not going to include them here. I've seen them. Tim Carmichael writes that he did not believe that Chris Gabehart's actual role was what coach said it would be. So he seems to agree with Gabehart in a text message that was included in this filing. He says that on November 13th, so about a week later, less than a week later, he gets an unsolicited offer from Spire Motorsports. He says, following the receipt of this offer, he creates a folder called Spire. And the reason he does that, he says, is he used it as his personal working space to evaluate the job offer and consider his options, since he understood they were working toward a mutual separation agreement. So he says, while JGR characterizes this as, hey, he created this folder of stuff he was going to take with him, he's saying, I created this folder knowing that we were leaving as my separate personal area where I could begin working on my Google Drive with stuff for my potential next job. That's what he says. He says, I did access that folder after it was created. However, I did not use any confidential JGR information, nothing that was in the folders while working in that file. All times I understood my confidentiality obligations and had no intent to violate those obligations. So fast forward a month now. He gets there was a letter from JGR saying that he not use any of the stuff. They respond, they say, yes, he will return and delete any JGR information. He again makes it clear that none of their JGR confidential information had been transferred to Spire. He also allows JGR's forensics examiner of choice. He says, you pick, and I will let you go through my Google Drive and my personal cell phone to find any JGR information and delete it. So he does that. By the way, he says he paid for that personally. So prior to turning over his devices, he says he executed a sworn declaration under penalty of perjury, certifying that he had done a reasonable search of his files and that the only confidential information he had was on those devices, his Google Drive and his personal cell phone. And those are the devices that were reviewed. So he again says, under penalty of perjury, I had not transferred confidential information belonging to JGR or any to JGR or to any third party, and he had not intentionally allowed any third party to view any of that confidential information. So he takes his cell phone to the forensic examiner on January 12th, leaves it there for the day, also gave his password so that they could access his Google Drive. He says, the forensic examination was completed. The results confirm what I had maintained. There's no evidence that I had transmitted, distributed, used, or otherwise shared any confidential information. No text messages, no emails, attachments, no dissemination whatsoever. Okay? So he says he also consented to the permanent deletion of everything they found on these devices And that deletion occurred on February 6th. In addition, he says he paused 2 extra months on moving forward with Spire or any other team because his goal and only focus was to prove to JGR, to the best of my ability, that their confidential information had not been transmitted. So he's saying, I delayed starting at Spire for 2 months just so I could reassure you that everything was above board, that I did not do anything. Okay. There's a thing about COBRA here, and we're going to get into that a little bit further down, so I won't repeat that. So there's confusion here over what his actual status is. They don't, because he asked the HR people officer, hey, like, I need my COBRA health insurance coverage to extend here because we're running out. She says if JGR was still in limbo after Thanksgiving, she'll make sure. But there's instead ongoing confusion about whether he's actually employed or not, that he's on gardening leave. Okay, they haven't worked out the separation agreement yet. So he says during this time, they stopped paying him. All the money he was normally owed under his contract, they stopped paying him beginning in November. But no, they never terminated him. So he says November 10th, he stopped working there, but they had not finalized the agreement. But during that time, they stopped paying him. So he says, in fact, this extends to his performance bonus in his contract, approximately $235,000, which he earned as a competition director for their success last year. They didn't pay this until January 20th, and that was because it came over a month after his lawyer said, hey, you haven't paid this out. So they finally paid it, he says, January 20th. But by the way, he says, so they're suing me for breaching the agreement. He says, well, actually, you breached my agreement. You never paid me. You breached my employment agreement. So you're in violation. The contract you're saying that I'm in violation of, you're in violation of. He says, furthermore, so because my health insurance didn't get transferred over to COBRA because I was never terminated, which, for those of you who don't know, when you're done with the job, you need your health insurance to stick around a couple extra months or whatever. You have COBRA to extend it so you can find a next job as like a holdover. And so it didn't get extended. Well, so he says, as a result of this, my family and I have had insurance claims denied due to coverage lapses caused entirely by JGR's administrative confusion and failure to effectuate a proper termination. So on February 5th, his lawyer sends a letter to JGR's lawyer explaining that the forensic examination had been completed. And now his lawyer says they're ready to finalize the separation agreement and move forward. So he says, we did all this stuff on our devices. And he says, by the way, you never terminated me for cause. And so by not paying me because you didn't terminate me for cause, you're in violation of state law. Well, we saw this letter that came out yesterday in JGR's filing. February 9th, they send him a letter after they've already stopped paying him, and they say, all right, well, now we're terminating you for cause. So they're saying, well, you terminated me without cause. We never worked this out. And they say, well, actually, February 9th, we did terminate you for cause. But he says, November 10th, this is when I was done here. So let's go a little bit further down here. So he says that termination notice was not legitimate. And because the Section 6, which we talked about before, that he says they owe me my salary. If they're not going to honor that, then they need to pay out the whole rest of my contract, which is $2.15 million more. So now this is a contractual disagreement. So he says, by the way, he doesn't think that they have any way to enforce the non-competition thing because he met his obligations, and he says he did not disclose the information. and he has always intended to honor that. He also says, to answer part of a claim in their lawsuit, he wasn't involved with any JGR employees leaving JGR to go work for Spire. So he also says that he became employed as chief motorsports officer, and he says, again, this is all, under penalty of perjury here by signing this statement, that he says, because they said, JGR says these services are the same. Chief motorsports officer is the same as competition director. He says, I do not provide services similar to the general type of services that I provided to JGR. He says it's different. He also says, further satisfy them. This is what he said in his statement too that he posted on social media. Through his lawyer, he said that Spire was willing to have someone look at Spire's computers to confirm that no JGR information had been transferred to Spire or used by Spire, and that Spire was willing to enter into an agreement themselves, separate from him, representing that it had not received any of this information and agreeing not to use any information from in the future either. Well, he says JGR never responded to this offer. Instead, JGR filed this lawsuit choosing litigation and public spectacle over the verification it claimed to seek. Strong words here. So again, he says, by the way, they have no rights, they have no basis here to claim this temporary restraining order because I didn't misappropriate any trade secrets. He says the forensic examination of his devices from the guy JGR chose confirmed I didn't transmit or distribute or share any of the information. I had and have no plan to compete unfairly. So he's saying he doesn't deny that he has this information on his devices, but he says, well, I didn't share it or transmit it or have any plan to share it. Here's a big line here. This is a notable one. He says, this lawsuit is not about protecting trade secrets. It is about punishing a former employee for daring to leave. He also says, listen, if you give them this temporary restraining order, it would effectively bar me from pursuing my livelihood in the only industry in which I have developed expertise over the course of my professional career. Any order prohibiting me from working in the specialized field will not merely inconvenience me, it will exile me from this profession. So he says, by the way, he goes on to say how badly this would damage him, obviously, right? So he asked the court to deny it. And the last thing, he says, by the way, I am willing to consent to further examination of my devices quickly to confirm that no trade secrets or confidential data have been misappropriated or used in connection with my employment at Spire. So he says, in addition to what's already been turned over and reviewed, if the court wants it, I'll double down and show you again quickly right now that nothing's been transferred. That's how sure he is. So that's his claim, and he attached text messages, emails, and other things which he say would bolster his claim. Well, we're going to find an answer to this quickly because this Friday at 1 p.m. in the same courthouse as the NASCAR antitrust lawsuit took place, a temporary restraining order hearing will take place. It's not with Judge Bell, so it's a different judge, but once again, NASCOURT will be in session. We'll keep you posted if there's any other filings. I won't be at that. I'll be at Circuit of the Americas, but I'm sure there'll be some interesting stuff to come out of that.